Good morning. Are you Lee Coney?
Yes, ma'am.
And Miss Coney, you've got two cases. One you're on probation for in cause number 24 DCCR 1600 on probation for theft of property with previous convictions. There's a new indictment that's been handed down in cause number 25 DCCR 1274. You're charged with possession of a controlled substance, also a state jail felony. It's my understanding that there is no agreement in either of these cases. Is that correct?
That's correct, Your Honor. I was speaking with Ms. Coney this morning and yesterday, and she has a request to make of the court.
This is a bad time to ask for new counsel. Once a probation revocation is set to move forward, the court's priority is efficiency, not shopping for lawyers. Unless there's a real conflict or incompetence, judges almost never grant substitutions this late in the process.
I'd like to have a new attorney.
Well, Ms. Coney, you don't get to pick a new attorney. Mr. Rojas is an excellent attorney. He's, I'm sure, talked with the assistant district attorney, is giving you that information and advising you. And so if you want to take some agreement, that's fine. If not, what's going to happen is today we'll go through that motion to revoke your probation. And I'll get pleas of either true or not true to those allegations. Then we'll reset that case for a sentencing hearing. I'll determine if you violated your probation. If I determine you have, I can either continue you, I can revoke you, I can do whatever at that point. And then depending on what happens on that case, I guess we'll see what happens on that new offense. And so do you want to talk to Mr. Rojas about that agreement, or do you want to go forward and leave it all up to me on your motion, I guess?
I plan to go forward.
With what? Just pleading open to the court?
Yes, ma'am.
Raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Will she waive the formal reading of the motion?
She will, Your Honor.
Ms. Coney, in 24 DCCR 1600, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2024 for the state jail felony offense of theft of property with previous convictions, and that was a 5-year deferred probation. Is that correct?
Yes.
The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, a state jail felony, November 1st of 2025. And is that true or not true?
That's true.
Count 2 alleges that you committed the offense of possession of a controlled substance, penalty group 3, and I'm guessing that's a misdemeanor
I
offense?
think so, Judge. The case is not yet, that case has not been filed.
Okay.
It's awaiting testing right now. It's in progress.
Okay. And I'm not sure if that's a misdemeanor or not then. Penalty group 3, less than 28 grams on November 1st of 2025. And is that true or not true?
I'm sorry, what was it?
It's the same date. It's just a different drug. November 1st of 2025, when you were arrested, it was for possession of 2 different types of drugs.
No, ma'am. No,
Okay,
it's
so not true to count 2. Count 3 alleges that you failed to report to the probation department July 24th, August 21st, October 8th, and October 29th of 2025. And is that true or not true?
I'm sorry, he was trying to tell me something while you were talking.
So count 3 alleges that you failed to report to the probation department on July 24th, August 21st, October 8th, and October 29th of 2025.
That's true.
Okay. Count 4 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance. Mr. Nichols, did you read that one?
Failed to never become intoxicated or be under the influence of any intoxicating substance.
And that on or about
March.
the March 19th, 2020.
I'll just drop 4, Judge.
Do you want to,
This isn't my file. I don't know the details
Well,
of the
let's
violations, and I can't amend right now.
okay.
I don't know what.
What I'm going to do is, at this time, I don't want it I want to know whatever allegation that is at the appropriate time.
I can see it here, Judge, and I can orally amend that. What it's supposed to allege is that she tested positive for cocaine on March 19th, 2025.
So any objection to the amendment reading in that on or about March 19th, 2025, the defendant tested positive for cocaine? Mr. Rojas?
No objection.
So count 4 alleges that you failed to never become intoxicated or be under the influence of any intoxicating substance, and that you tested positive for cocaine March 19th of 2025. And is that true or not true? Count 5 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
I'm not.
Count 6 alleges that you failed to submit to alcohol and/or drug screening on July 29th of 2025 at the direction of your probation officer. Is that true or not true?
It's true.
Okay, you'll get to explain later. Right now, just true or not true. Count 7 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? I'm sorry?
Yeah, true.
And then count 8 alleges that you are behind in your court-assessed fees as of November 3rd of 2025 in the amount of $575. And is that true or not true?
As of November. On that day, we know.
Yes, that's true.
Okay. Did you enter your pleas of true to counts 3, 4, 6, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true?
Well, with the payment, that my payment is
Missing reports, failed drug tests, skipped classes. These sound minor to viewers, but legally they're enough. On deferred adjudication, the state doesn't need a new conviction to revoke probation. Pattern alone can collapse the entire deal.
thought up now.
Okay, I'll just take off number 8 and put not true on that one. So 3, 4, 6, and 7, did you plead true, again, freely and voluntarily?
Yes,
And because those counts are actually true.
yes,
All right, then I'm going to find counts 3, 4, 6, and 7 true, find that you entered those pleas freely and voluntarily, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset the case for a hearing. I would anticipate, Mr. Nichols, that you would have some evidence with regard to the count 1, the new
Yes, Your Honor, the
offense.
state will prove up.
Do you think we would need more than an hour or so?
I wouldn't think so, Judge.
Okay.
It appears to be a traffic stop.
One
Judge will count.
or two, I guess, a 2 witness.
Yes.
We need
At least
lab.
two. Hour and a half, I would think.
Okay, we'll get it set for an appropriate day. Just everybody make a notation that it will be set for a hearing for that. Anything that you think is important for me to know, get that information to Mr. Rojas, and he'll present it to me on your behalf when we come back. And if I can get an updated pre-sentence report, that would be great as well. Thank you, ma'am, for being here. You can go back with the bailiff. Oh, actually, come over here to the clerk. She needs your fingerprint before you go back with the bailiff. Good morning. Are you Marquise Jones? And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, in cause number 21-37263, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 23rd of 2022 for the offense of theft of material, and that was a state jail felony, and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of evading arrest on June 20th, 2024 in Harris County, Texas. And is that true or not true? And then count 2 alleges that you were at a location other than your residence at approximately 1:30 a.m. June 20th of 2024. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And did you plead true to those counts because they're actually true? Speak up, please. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
And I think I said your plea of guilty instead of true, but your pleas of true. Anyway, all right, so I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of material, aluminum. I guess it goes on, aluminum, bronze,
Aluminum,
copper.
bronze, copper. They were cutting catalytic converters.
And so find you guilty and sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir, and thank you for being here, sir.
Thank you.
Oh, my nose is sneezing right there, and now I'm sneezing. Good morning, sir. Are you Alvin Wade?
Yes, ma'am.
And Mr. Wade, in cause number 25 DCCR 1648, you're charged with a third-degree felony offense of possession of a prohibited substance in a correctional facility from July 6th of 2024.
This is the moment everything becomes real. 15 years isn't generosity, it's a lifeline. Rejecting it means gambling against a habitual offender enhancement where the floor is 25 years. Once you go to trial, that leverage disappears forever.
Your indictment alleges that you were previously convicted of aggravated sexual assault on a child, a first-degree felony, January 22nd of 1998, and after that was final, you were convicted of failure to register as a sex offender, a third-degree felony, November 26th of 2018. What that means is that if you go to trial and you're found guilty in this case, and if those prior convictions are true, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand the possible range of punishment if you're found guilty at trial?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature with Mr. Rojas's and shows that the district attorney's office has made an offer, if you would like to enter a plea of guilty, for a 15-year term in prison. So that would be to go on counts 1 and 2 only. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that?
With counts 1 and 2.
So counts 1 and 2, that just makes it a second-degree felony instead of the habitual. So it's the offense you're charged with and one of your priors instead of both of your priors.
Oh.
So that's how we get to 15 instead of that minimum of 25.
Oh.
Make sense? And so do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get your case set for trial, Mr. Way.
And, excuse me, can I say?
Uh-huh.
I want to invoke my Sixth Amendment constitutional right,
To,
speedy trial,
you're lucky because in this court, we only have 50 cases waiting on trial. So every case is getting a speedy trial now. So you will get set for trial as quickly as possible, and we'll get your case taken care of within a very short amount of time. Now, I wanted to ask you, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release Mr. Rojas. I can appoint another attorney who could begin preparation for trial probably a little quicker. Is that okay with you?
where I have the same right to gather the evidence
Yeah, of course. Your attorney will get all of the discovery. They'll go over all of that with you, and then we'll get your case set for trial.
And like pictures, that like, I need him to take some pictures.
Just listen. Let's start with, do you want a different attorney so they can prepare quicker, or do you want to keep Mr. Rojas?
If he gonna,
Any
he
attorney,
told me he was a cop out lawyer.
he, I can't imagine that Mr. Rojas
Yeah, he
used
said-
those
said
words.
it's on the kiosk. That's what- you know what I mean? Yeah, he-
I said she'll give you a new lawyer tomorrow. It's just somebody that they can get ready faster than you.
you say you're a cop out lawyer that take deals with the DA. I need a lawyer that's gonna help me.
Any of the attorneys who I can appoint in my court are going to represent you to the best of their ability.
Your Honor, if I may, Mr. Rojas has negotiated with me back and forth on this case. We've discussed this case at length, both the strengths and the weaknesses in the state's case, just for the record.
I have no doubt that Mr. Rojas has done an excellent job already, but Mr. Wade, I just need to know
Okay.
if I have your permission to release Mr. Rojas and appoint someone else, or do you want to keep Mr. Rojas? Is that
Well,
simple?
I'm gonna take your advice.
It's not advice.
Oh.
Don't be putting words in all of our mouths. I'm not giving you
said
advice.
He was a good lawyer, huh?
I'm saying everyone on this list is a good lawyer. So you can keep Mr. Rojas, or you can get someone else off of the rotation who could probably start your preparing for your trial a little quicker. Mr. Rojas
Okay.
just handles a lot of cases for me.
Okay. Then I need a lawyer that, when I handle my case is
Quicker, because you're asking for a speedy trial and all. Perfect. So I'm going to release Mr. Rojas. I will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Yes.
You can go back with the bailiff.